Case in Point with Suzanne Sherman.
I'm fixing to commensurate this trial here. We gonna see if we can come up with a verdict up in here.
Well, good morning, everybody, and welcome to a brand new show here on the Cerberus Radio Network, where we defend liberty and freedom from the flames of tyranny. My name is Suzanne Sherman. I will be your host for the next half hour. This is going to be a 30-minute show that is going to be packed with information. The topics we're going to have are going to be pretty heady, so we're just going to keep them short and brief, and then you can find further information that we will provide for you. Today's going to be a very special episode. I decided the idea to have this show hit me last week when Justice Kennedy announced his pending resignation, retirement from the Supreme Court, and watching the reaction on social media, across the news, everywhere, everybody waiting with bated breath on one side. The first issue that seemed to come up was, what about Roe versus Wade? What's going to happen with that? Ostensibly, we're under a system now where we are looking at a single individual to change the policy across this continental landmass known as the United States of America. As we're going to discover as we go through my other shows, also on the Cerberus Network, radio network here, that this was not the way we were intended to be when this union of sovereign and independent states came together for limited purposes. So what I decided to do was let's look at landmark cases that have overall contributed to the inversion of this system, of this federal republic we have. And we're going to start today with the case of all cases, Marbury versus Madison, with, in my opinion, the expert of all experts, Dr. Kevin Gutzman, who is he's a history professor at Western Connecticut State University. He is the author of, I think should be required reading for every elected official and Supreme Court justice, A Politically Incorrect Guide to the Constitution, co-author of Who Killed the Constitution with Tom Woods, James Madison, Making of America, and Thomas Jefferson, Revolutionary, is the most recent book, A Radical's Struggle to Remake America. Chapter 1 of that book, by the way, has one of the best discussions of federalism I have come across. Kevin is also on the faculty of Liberty Classroom, and we have a special offer for followers of Cerberus Radio Network. Go to libertyclassroom.com, and in the enter code, or the code, you can put CRN for Cerberus Radio Network, and you will get a significant discount. A basic membership will go from $89 to $49. And you will know, if you follow some of these cases or the classes here, you will know more about our founding principles than I would say any federal judge. Kevin Gutzman. Dr. Gutzman, welcome to the debut episode of Case in Point.
I'm happy to be here.
Let's talk about Marbury versus Madison. It is the first class that I pretty much know every lawyer, aspiring lawyer, takes in constitutional law. What people really understand about Marbury versus Madison, they take home the single point issue, the conclusion that established once and for all the Supreme Court is the ultimate and final arbiter of all issues, laws, constitutional. Can you expound upon that? I want to get it. I want to know, is that a reasonable assumption, and how did this come about? If you look into the background and the history, this really came about as two competing factions were vying for power in this newborn republic. Why don't we have you get into a little bit about these competing interests and how this case came about?
Well, first thing to know about that case is that it didn't really come to stand for the idea that the Supreme Court was the ultimate authority on matters constitutional until the 1950s, when in a case called Cooper versus Aaron, the Supreme Court said, it has always been understood that this court has the final say on constitutional questions. From that point on, people in law schools were taught that you should read that principle backwards. And so they've come to see Marbury versus Madison as having claimed that. But John Marshall and the Supreme Court didn't claim that all matters constitutional were supposed to be resolved by the Supreme Court. They said that the matters that were before them, that cases that were before them had to be decided by them. It couldn't be avoided. In general, however, people in the 19th century thought that constitutional questions should be decided in Congress, not by the Supreme Court. So the case of Marbury versus Madison itself was controversial when the decision was announced, but not for the reason people might think. It wasn't controversial that the federal courts were going to exercise the power of judicial review, that is, the power to pass on the question whether a particular statute was constitutional. People had been told during the ratification campaign, that is, during the Article 7 process that put the Constitution into effect, that federal courts would exercise this power. So actually, during the ratification campaign, the only discussion of this question in the Virginia Ratification Convention went this way: federal judges are going to have the power of judicial review, said Federalists. Well, we should be so lucky, but I doubt it, said the leading anti-federalist Patrick Henry. And so basically nobody said, wow, that's a really bad idea. The same thing happened in New York, where the Federalists laid out the claim that the federal courts would have this power of judicial review. There were other states, too, where the idea came up, and it seems to follow logically from the requirement that federal judges take an oath to uphold the Constitution and Article 6's statement that the Constitution, statutes made pursuant to it, and treaties made under its authority would be the supreme law of the land. What was controversial then about the court's performance in the case of Marbury versus Madison was the way that the majority opinion, or the way that the court's opinion, it was the only opinion in the case, was structured. Today, if you file a suit in a federal court, the first thing you have to assert is that the court has jurisdiction. You have to lay out the basis of the court's power to decide the case. And in general, in America, we have two kinds of courts: state courts, federal courts. A state court can decide any legal issue. A federal court can only decide cases that have federal issues. So you'd begin by saying, all right, Your Honor, here is the ground on which my client is filing this case in this court. And the court would decide this jurisdictional question before it got to any other questions. In Marbury versus Madison, however, when Chief Justice Marshall read the opinion of the court, he started with the matters in dispute. And so he said there were three questions in the case. First, did Marbury have a right to the commission he was claiming? That is, did he have a right for the court to make Secretary of State Madison, James Madison, give him his commission as a Justice of the Peace in the District of Columbia? Secondly, the court said, we have this question whether there's a remedy. That is, if he has a right to his commission, is there a legal remedy? And Marshall said, well, in general, the common law assumes that where there's a right, there's always a remedy. It happens there is a remedy in this kind of a situation where somebody's got a commission that he's entitled to, but he's not being given it, and that is an order from a court to the executive official telling him, give the man his commission. And in this case, it would be a writ of mandamus, which was what Marbury's counsel had requested. Then finally, the court said he had a right, there was a remedy, do we have jurisdiction? And at that point, they said, well, no, we don't, because the statute that purports to give us jurisdiction over cases for writs of mandamus is unconstitutional insofar as it claims to give us jurisdiction over suits for writs of mandamus. So what had happened was that Marshall had essentially read the Riot Act to the Jefferson administration. Look, this man has a right to this commission, he said, and then there is a remedy, and it just happens that you have decided not to give him his commission even though he's entitled to it, but we can't do anything about it because the Constitution says we only have original jurisdiction in certain kinds of cases, and cases for writs of mandamus are not among them.
So do you think if he had addressed the jurisdictional issue first, that Marshall would have been forced to forego the golden opportunity to upbraid the Jefferson administration?
Well, that's why he did it that way. Sure. Actually, it's kind of interesting here. There are a couple of things that are kind of interesting about Marshall's performance, besides the fact that it was just nakedly political judging of the kind that the Federalist judiciary was in the habit of. One thing is that Marshall himself was arguably an interested person in this case. That is, what had happened was that at the very end of the John Adams administration, which went from 1797 to 1801, the Federalist Congress passed what's called the Judiciary Act of 1801. And among other things, the Judiciary Act of 1801 created dozens of new posts for justices of the peace in the District of Columbia. The president nominated several people for these posts. The Senate confirmed these appointments immediately. Then Adams signed commissions for all the people who were supposed to get these new offices, including William Marbury, which were sitting on John Marshall, the Secretary of State's desk, when the new president, Thomas Jefferson, showed up for work. So Jefferson later said that he went into the Secretary of State's office, he saw these commissions sitting on the desk, and he immediately decided not to deliver them. So Marshall claims that Jefferson really, the suit's against Madison, but really he's attacking Jefferson for not delivering these commissions. That Jefferson had an obligation to do this because the Constitution established a two-step process for conferring a judicial post on someone. One, the president had to nominate the person, and then the person could be appointed through the advice and consent of the Senate. So as far as Marshall was concerned, what his opinion said in the case was, once you had the nomination and the confirmation, everything the Constitution required for the interest in the office to be vested in, for example, Mr. Marbury. And that's why he could say, Mr. Marbury has a right to this commission. Now, Jefferson didn't agree with this. Jefferson analogized the situation to one in which there was a transfer of land title. He said, where you have a deed, the transfer isn't final until the deed has been delivered. So if you purchase land and the seller filled out a deed, but he never actually put it in your hand, then you never had the title vest in you. Jefferson said that was the situation Mr. Marbury was in. Yes, the president nominated him. Yes, the Senate confirmed the appointment, but the president's appointment only becomes effective, said President Jefferson, former President Jefferson, when the office holder actually receives the commission. And I decided not to take that third step. So not only was Marshall an interested person, it was his omission that left those commissions sitting on his former desk in the Secretary of State's office. But then, arguably, and I think actually validly, Jefferson was right about this question, how many steps there are in giving somebody one of these appointed offices. The president nominates him, Senate confirms the nomination, the president gives the man his commission. So it was just a squirrely performance if you assume that what Marshall was really about was stating the law. But what he was really about was not stating the law. What he was about was upbraiding President Jefferson, who had already, and whose administration and party in Congress had already annoyed the Federalist judges grievously by, among other things, passing the Judiciary Act of 1802, which repealed the Judiciary Act of 1801 and actually abolished this office that Marbury claimed he was entitled to.
You know, when you mentioned the two requirements, that the commission, and then you add the third, that the commission has to be delivered, was the third requirement that going beyond the nomination and the confirmation, was that actually a written part, or is that something that Jefferson just decided on his own?
The Constitution says the president can appoint people to these offices with the advice and consent of the Senate. So it doesn't say that it's a two-step process, it just names two steps. But Jefferson's reasoning was, just as in a again, just as in a land sale, that it's not actually final until the president confers the office on somebody by giving him his commission, which, of course, makes sense. We know that routinely the Senate receives requests from the executive branch for confirmation of hundreds, sometimes even thousands of military promotions. And the Senate will confirm these promotions just kind of pro forma, you know, without going into the record of every captain who's being promoted to major and so on in the military. And no one, I think, would say that if between the Senate confirmation of some guy's promotion from second lieutenant to first lieutenant, he, you know, rapes somebody and gets thrown in prison, he's still entitled to be a first lieutenant. So it seems to that is that the president could withhold the commission, and the fellow would never actually receive the new rank. That's I think a valid argument. But the point is, the reason for the controversy at the time, there was controversy over the Supreme Court's performance in the case of Marbury versus Madison. Jefferson and the Republicans didn't object to the idea that the federal judiciary was going to have the power of judicial review. What they objected to was this pretty brazen political attack on them in the form of the court's opinion in the case. That is, this was all just an attack on Madison, meaning really Jefferson, for supposedly scoffing at the law and not giving Marbury what he supposedly was entitled to, which was this commission.
Pretty much like when we have any kind of dispute with interpersonal relations, the object that's the subject of the dispute itself typically is a symptom of a greater problem. In this case, we really had, again, the Federalists and the Republicans who had this conflict going back to, I would say, the genesis of this union, where we had the Hamiltonians, the mercantilists, the financial aspect, and then the agrarian Jeffersonian contingency. Interestingly enough, you mentioned a conflict of interest with Justice John Marshall, Supreme Court Justice John Marshall. It's not the first time, it wasn't the last time that he had a bit of a conflict of interest. And I know we're going on a bit of a tangent, but you did mention this. And in your book, The Politically Incorrect Guide to the Constitution, you mention Yazoo scandal. And this was an issue with the Contracts Clause and Fletcher v. Peck. John Marshall was also involved in that case, and he should have recused himself. Let's take a moment. We only have 30 minutes, but we do have time to address this issue, because I think it's important to understand that one of our most famous Supreme Court justices was not above behaving in a manner, I feel, that was not part of our Republican values.
Well, Marshall actually did recuse himself in the case of Martin versus Hunter's lessee, which the court handed down in 1816. The majority opinion ended up being supposedly written by Joseph Story, at least it has his name on it. Although if you read the opinion with John Marshall in mind, you might think that it sounds kind of like Marshall. Okay. What was the issue in that case was that there were land titles in Northern Virginia in dispute, and the matter had been litigated repeatedly and for over a long period of time in Virginia courts. And then the question was whether the case could be appealed from the Virginia Court of Appeals, what's now called the Virginia Supreme Court, to the U.S. Supreme Court. Marshall, because he held some of these titles, recused himself from that case. In Fletcher versus Peck, in Dartmouth College versus Woodward, and some other cases, Marshall, I think, twisted the meaning of the Contracts Clause in order to find that the Supreme Court could decide the case, even though the matter at issue wasn't really a contract, or there wasn't. Well, for example, you mentioned the case of Fletcher versus Peck. What happened there was that you had a fraudulent land sale by what we now know as most of the states of Alabama and Mississippi, which in the colonial period have both been parts of Georgia. And after the land sale went through, it was discovered that all but one member of the Georgia legislature had been bribed by land companies that bought land in the land sale. So at the next legislative election, all but one member of the legislature was voted out. Imagine that. So the new legislature comes in, and the first thing it does is repeal this land sale, right? This is a fraud, and we want our title back. We're going to consider this transfer from the state of Georgia to all these private purchasers as invalid. Marshall ultimately says, well, no, you can't do this. It violates the Contracts Clause of Article 1, Section 10 of the Constitution, which says that no state can pass a law impairing the obligation of contracts. Notice, in saying that the revocation of the land sale violated the Contracts Clause, Marshall had to assume that those were contracts, that these fraudulent sales were valid. But, of course, where you have a fraud, you don't have a contract. If you or I named somebody to have power of attorney, and he went out and made a deal with some third person that in exchange for a payment to him, he would sell your house or my house or, you know, our cars or whatever we owned, any court would say, well, that's not valid because your fellow exercising your power of attorney was bribed, so there wasn't ever a valid contract. But Marshall left that aside, found that this contract was valid, or all these contracts were valid, and so they couldn't be revoked by the legislature of Georgia. What this meant was that the people of Georgia were just rooked out of all this land, virtually all of today's states of Alabama and Mississippi. And why would Marshall do this? Well, because, as I mentioned, in connection with Martin versus Hunter's lessee, Marshall was a huge land speculator, and he tended to always to side with landowners in these kinds of cases, with land companies, with big buyers.
So we were seeing this going off the rails, I always argue, from the very beginning. How would you have seen an appropriate outcome for Marbury versus Madison?
Well, I think the outcome was fine. That is, I think it was perfectly valid for the court to say we don't have jurisdiction over this kind of case because the Constitution says the Supreme Court will have original jurisdiction over only a handful of types of cases, and this is not one of them. And again, if you or I went into federal court today with a lawsuit, first article of our complaint would have to be, here's the ground of your jurisdiction, Your Honor. And the court would consider that right away. And if it got to, well, we don't have jurisdiction because this is not one of those types of cases over which the Constitution gives us jurisdiction, there wouldn't be any discussion of the question whether Marbury had a right and whether there was a remedy and all that stuff. That would be beside the question. Jefferson actually, considering Marshall's behavior in this case and several others, said that what Marshall tended to do was to go beyond the bounds of the case. He tended to scout out new territory and kind of give an advisory opinion that lower level Federalist judges could use as ground for claiming more power for themselves in future cases. That was really what he was doing. So it was an abuse of his position, I think.
This has been fascinating. I think the biggest misunderstanding with Marbury versus Madison is it established for the first time the principle of judicial review, and that's really not the case because there was judicial review in other aspects of government and in other countries as well. So this wasn't anything new. If you do want more information on that, again, go to libertyclassroom.com, get yourself a basic membership, at least go to CRN when you go to the checkout counter. Also, for anybody that's interested in continuing to follow this show, again, case in point, Kevin Gutzman, my first guest, author of The Politically Incorrect Guide for Constitution. I will be referring to this book. I refer to it all my other shows as well frequently. Fantastic analysis of also the Supreme Court's role in usurping the Constitution in many cases, including the incorporation doctrine, which we'll be discussing more. I'll have more cases coming up. I hope that you can come back on the show. You just finished, by the way, a series of lectures about Thomas Jefferson for Liberty Classroom. Is that correct?
Right. There's going to be a new Jefferson course up at the Liberty Classroom site within the next few days. So right in time for the 4th of July, you can have access to this new Jefferson course by purchasing your own access to Liberty Classroom.
Do you think the role of Marbury versus Madison has been overstated? How much does it affect us today? I was surprised at the start of the show when you said that it really wasn't understood or claimed to be setting the precedent for judicial review in the 1950s. I did not know that.
Well, okay. I want to draw a distinction between the power of judicial review and the idea that the Supreme Court is the ultimate authority on all constitutional questions. So what you asked me at the beginning of our discussion today is whether this had always been understood as making the Supreme Court ultimate authority on constitutional questions. And I said, no, that idea actually comes out of Cooper versus Aaron, which is a 1958 Supreme Court decision. But the idea that the federal courts would have power of judicial review, that is, that they could decide cases that came before them on constitutional bases, and that they could say that federal statutes in conflict with the Constitution were going to be deemed invalid. This was an idea that was discussed during the ratification campaign. And actually, there were a couple of states, Pennsylvania and Virginia, where state courts had already exercised the power of judicial review even before the federal Constitution. And there were also lower federal court cases before Marbury versus Madison in which federal judges exercised the power of judicial review. So the reason why Marbury is famous is that it was the first time that the federal Supreme Court claimed the power of judicial review, though it continued to concede that, again, these questions of constitutionality were going to be mainly for Congress to debate and decide. And it wasn't the federal courts who had ultimate authority. It was the Congress that had ultimate authority over that kind of issue all the way up to 1958.
Final thoughts as we wrap up the show. Gotta ask you your thoughts on Kennedy. I will have you know that as I'm going through social media and seeing the banter and the suggestions for a Supreme Court justice, I think the most common name that I see thrown about as the perfect candidate for the next justice to replace Kennedy is you.
Well, I want to thank my son and daughters for spreading my name to that effect.
It was more than just three people, quite honestly.
That's flattering, of course. That's flattering.
What you really illustrate for us is because you're not only a historian, but you are also a recovering attorney, as am I. And what your book showed me was what I was never taught all the way up through my legal education. And that is, for instance, the incorporation doctrine. None of this actually made sense to me. And as we progress and have more episodes, this is going to make more sense to people. It is really hard for people to understand the actual intended function, for instance, of the Bill of Rights. You're seeing people argue for their Second Amendment rights, fighting from state laws. The goal of this show is to bring people like Dr. Gutzman here for you to understand what the original intent of this Constitution was. To do that, you really are behind the eight ball if you got your education in what I call the legal education industry. I refer to this as the malfeasance of the legal education system. Kevin, you and I had discussed when we were doing bar review for the multi-state, the multiple choice part of the bar exam. If you have to choose between two answers, or four of them, but two of them are competing, obviously they have the 14th Amendment and the 10th Amendment. We are taught, if you want to save some time, just always go with the 14th Amendment. That is in direct contravention to our founding principles. I try to tell people that unless there's an issue that has been delegated to the general government by these states in Article 1, Section 8, the answer is always going to be the 10th Amendment. However, if you want to pass the bar exam, you have to actually get it wrong. The purpose of this show is to get people to understand what we were intended. I want to encourage everybody, go to kevingutzman.com. You can follow him on Facebook, also on Twitter. Latest book is Thomas Jefferson Revolutionary. You have one also in the works. What's that one going to be called?
The Virginia Dynasty. It's about the first three presidencies of the 19th century, Jefferson, Madison, and Monroe. It was essentially one continuous administration of those three Virginian close friends and allies.
Well, I hope everybody enjoyed this very heady discussion on a case that always had me pretty confused. So, Kevin Gutzman, I want to thank you for joining me today on the debut episode of Case in Point. We hope to hear more from you soon. Everybody, thank you for joining us today here on the Cerberus Radio Network, where we defend liberty and freedom from the flames of tyranny.